again, he intended for that to be the result. Here, there's no allegation that Ms. Gardner intended for discovery to be violated by her subordinates, that Ms. Gardner intended for people not to show up to court and therefore have cases dismissed, or any of the other 40 examples, or if that they come up with. There has to be that nexus. So there has to at least still be some intentional conduct alleged by Ms. Gardner, and they don't get there. But moreover, they don't even allege, if it were vicarious liability, it would be the same standard of intent against the lower officer as it would be against the higher officer, right? That one transfers to the other. They don't have any allegations that even the assistant circuit attorneys intended for bad results to happen in these, less than 0.2% of the cases that have been done in Ms. Gardner's tenure.
But if we're reading the allegations broadly, as I have to do, isn't there kind of this general allegation from the Attorney General's office on each of these counts that there is a duty to do something, a duty to prosecute, and that Ms. Gardner has willfully neglected her duty to do so, and then their evidence of that is, that there have been a lot of dismissals. The number of cases that we're talking about. It seems that if we look at it really, if we get down into a granular level on all of this, it's harder than if we look at it at the allegations more broadly, as really I'm supposed to be doing on a motion to dismiss.
Sure. Their evidence of willful conduct is non-willful conduct. What they have to show is something more than that. In every single other ouster case, every single one where an ouster was successful, or where it went to a hearing or a trial or something like that, there has been a specific allegation about the intentional conduct of the public official at issue. Simply concluding that they willfully, intentionally violated some duty, but then showing facts that don't actually show that they willfully or intentionally violated a duty was not there.
Isn't kind of the mental state of someone necessarily something that you have to allege and prove by circumstantial evidence?
It certainly can be alleged and proved by circumstantial evidence, but they haven't alleged it. All they've done is stated conclusions. They haven't stated a single allegation against Ms. Gardner that she intended for any of these outcomes to happen. They have to have something more. They have to have the connection to organized crime, like in those old prosecutor cases. They have to have the young, inexperienced prosecutor who was letting his friend off with the nolle prosequi, like in the Moody case. They have to have any of the other well-pleaded facts that were shown in these other cases, and they simply don't get there. The law of Missouri demands more. Just making conclusory statements that Ms. Gardner willfully violated or neglected some duty is not enough. Missouri's fact pleading, that might work in federal court, but that doesn't work in this court. This is an attack on the democratic process by someone who was never elected. And if Mr. Bailey doesn't like the job Ms. Gardner is doing, that's his right. That's his First Amendment, his right under Article I of the Missouri Constitution, and he can support a different candidate at the next election and hope the people of St. Louis agree with him. But the law of Missouri doesn't allow him to do what he's trying to do here and use this court to oust Ms. Gardner for stuff that he disagrees with.